Hello and welcome to the Minimum Competence episode for Friday, March 1st, 2024. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, we have Musk suing OpenAI, a pivotal Trump-Georgia case hearing, and a sentencing in Elijah McClain's death. Let's remember, March comes in like a lion and out like a lamb, just like today's legal news. On March 1st, 1875, this day in legal history, a significant milestone in the journey towards civil rights in the United States was reached with the enactment of the Civil Rights Act of 1875. This groundbreaking legislation aimed to eliminate racial discrimination in public accommodations, such as inns, public conveyances, theaters, and other places of public amusement, declaring that all persons, regardless of race, color, or previous condition of servitude, were entitled to the full and equal enjoyment of these facilities. The act represented a bold step towards equality, affirming the rights of African Americans and other minorities to access public services and spaces without discrimination. However, this progressive movement faced a severe setback in 1883 when the Supreme Court, in a series of decisions collectively known as the Civil Rights Cases, declared the Civil Rights Act of 1875 unconstitutional. The court argued that the act exceeded the powers granted to Congress by the 13th and 14th Amendments, stating that the federal government could not regulate the conduct of individuals or private businesses. This ruling effectively removed the protections afforded by the 1875 Act, leaving African Americans and other minorities vulnerable to segregation and discrimination in public accommodation for decades to come. The Supreme Court's decision underscored the limitations of the federal government's ability to intervene in matters of racial discrimination in the private sector, a stance that persisted until the civil rights movement of the 20th century. It wasn't until 1957 that Congress would pass another piece of civil rights legislation, marking a long hiatus in the legislative battle against racial discrimination. The 1883 ruling and the ensuing period of legislative inaction highlight the challenges faced in the pursuit of equality and justice, demonstrating the complex interplay between law, society, and the fight for civil rights in America. Elon Musk has initiated legal action against OpenAI and its CEO, Sam Altman, accusing them of deviating from the organization's foundational objective of prioritizing humanity's welfare over profit. Musk, a co-founder of OpenAI, who has since divested his stake, asserts that OpenAI's partnership with Microsoft Corp has led the AI startup away from its commitment to open-source technology development, aligning instead with corporate interests. This lawsuit highlights Musk's ongoing concerns about artificial intelligence's potential dangers, especially in the context of rapid advancements and widespread adoption triggered by OpenAI's ChatGPT. Despite claiming to uphold a charter focused on the broad benefit of humanity, Musk argues that OpenAI has effectively become a closed-source de facto subsidiary of Microsoft, betraying its original mission. The legal challenge also scrutinizes the reorganization of OpenAI's leadership, particularly the events surrounding Altman's brief removal and subsequent reinstatement as CEO, which Musk attributes to a collusion between Altman, OpenAI President Greg Brockman, and Microsoft. This shift in governance, according to Musk, replaced a board previously dedicated to AI ethics and governance with individuals more oriented towards profit-making and political connections. The lawsuit emerges amid a context where OpenAI's innovations like ChatGPT and GPT-4 that powers it have propelled AI integration across various industries, with Microsoft leading the charge in leveraging these technologies for its services. Musk's legal action not only spotlights a significant rift within the AI community, but also signals potential ramifications for OpenAI's future direction and Microsoft's burgeoning AI ambitions. In Georgia, a judge is scheduled to preside over a critical hearing concerning former U.S. President Donald Trump's attempt to disqualify the prosecutor, Fani Willis, in his election interference case. This motion stems from Willis's undisclosed affair with Special Prosecutor Nathan Wade, which Trump and his co-defendants argue represents a conflict of interest. Trump, leading the race for the 2024 presidential nomination, faces charges of attempting to unlawfully influence Georgia officials to reverse his 2020 election defeat. Despite pleading not guilty alongside 14 others, a potential disqualification of Willis could introduce significant delays into an already complex racketeering case, though it would not necessarily terminate the proceedings entirely. During recent hearings, Willis acknowledged the affair with Wade, but disputed allegations regarding its timing and impact on the case. The controversy surfaced after a defense lawyer for a Trump co-defendant cited the relationship as a conflict of interest that unjustly benefited Wade. Despite the defense's accusation of deceit regarding the affair's onset, Willis and Wade maintained that their relationship commenced post-hiring, asserting its irrelevance to the case's integrity. Moreover, Trump is entangled in 3 additional criminal cases, including allegations of hush money payments, efforts to contest the 2020 election outcome, and mishandling of classified documents. His legal challenges are further complicated by debates over the trial dates and potential presidential immunity. Trump contends that these legal battles are politically motivated attempts to thwart his political aspirations, emphasizing the unique vulnerability of the state court case in Georgia to his potential presidential powers, unlike the federal cases. In Colorado, a significant sentencing is forthcoming for Peter Chichuniak, a paramedic found guilty in the 2019 death of Elijah McClain. McClain, a young black man, tragically lost his life after a police encounter involving a chokehold, followed by medics administering a potent sedative. Chichuniak, convicted of criminally negligent homicide, potentially faces up to 16 years in prison, marking a rare instance where paramedics have been held accountable in court for their actions during an emergency response. His colleague, Jeremy Cooper, also guilty of the same charge, awaits sentencing later in April. This case, the last in a series of trials stemming from McLean's death, underlines the legal and societal repercussions following the incident, which initially led to no charges against the involved parties. It was not until the global outcry after George Floyd's murder in 2020 that Colorado's Governor Jared Polis initiated a re-examination of the case, culminating in the 2021 indictment of the officers and paramedics by a state grand jury. McLean's encounter with the police on a warm August night in 2019, flagged for wearing a ski mask and appearing suspicious, quickly escalated to a fatal confrontation. The updated autopsy report in 2021 attributed his death to complications from the administered ketamine, contrary to the initial, quote, undetermined cause. This legal and moral saga underscores the renewed scrutiny on law enforcement and medical response practices, especially in interactions with Black individuals, reflecting a broader call for justice and accountability in the wake of national protests against racial injustice. And with that, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. Reviews go a long way towards helping new listeners to find our show. If you have a moment and can leave a rating or review on your podcast player, we'd sure appreciate it. And if you know someone that might be interested in a story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly not that. Minimum Competence is available at minimumcomp.com and wherever you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here on Monday, and until then, note, we are continuing our stated aim to start closing out the week of shows with a musical piece to feature. That will make these Friday episodes seem especially long. We hope you'll stick it out and enjoy the featured piece, but if music, specifically classical music, isn't your bag, we get it. Our mouth sounds unrelated to the week's closing music end here. This week's closing theme is by Frédéric Chopin. Today marks the birthday of Chopin, the Polish composer and pianist who remains one of the most celebrated figures in classical music, renowned for his emotional depth, technical precision, and revolutionary approach to the piano. Born on March 1st, 1810, Chopin left an indelible mark on the world of music with his romantic compositions that blend technical mastery with lyrical beauty. His works, primarily comprised for solo piano, have captivated audiences and performers alike with their expressive intensity and innovative use of the instrument's capabilities. Chopin was not only a composer, but also an extraordinary pianist himself, known for his unique ability to convey emotion through music. His compositions, characterized by their nuanced dynamics and intricate melodies, continue to challenge and inspire pianists worldwide. Despite battling health issues throughout his life, Chopin's output was prolific, contributing vastly to the piano repertoire with nocturnes, polonaises, mazurkas, and ballads that explore the full range of human emotion. As we celebrate Chopin's birthday, it's fitting to highlight one of his most beloved pieces, the Fantasie Impromptu in C-sharp minor, opus 66. Composed in 1834 but published posthumously in 1855, this piece exemplifies Chopin's ability to fuse technical brilliance with deep emotional expression. The Fantasie Impromptu is a whirlwind of passion and virtuosity, its outer sections marked by rapid fingerwork and ardent melodies, surrounding a serene, lyrical middle section that provides a moment of reflective calm. This piece, with its contrasting moods and technical demands, encapsulates the essence of Chopin's musical genius. As we close out the week, let the Fantasie Impromptu serve as a reminder of Chopin's enduring legacy, a celebration of his life and contributions to the world of music on his birthday. It's a piece that continues to inspire and move listeners, embodying the spirit of one of the greatest composers to have ever graced the art of music. Without further ado, Frédéric Chopin's Fantasie Impromptu in C-sharp minor, opus 66.